Cheshire Estate Legal Ltd and
Yes, Mr. Chasey.
I, on behalf of the appellant, Mr. Grant KC, with Mr. Baker, appears on behalf of the two respondents.
Yes.
I've been asked to mention that Mr. Baker and Mr. Grant would like Mr. Baker to sit on this row and just raise it on their behalf.
I'm also told that it's going to get very hot in this court, so if you need to take off a wig and gown, feel free to do so.
I'm very grateful. I wonder if I might do that straight away, because I don't think it's going to get any cooler.
The other thing I should say is that we have obviously read the judgment, the skeleton arguments, the agreed reading list, and large parts of what you asked us to read.
Yes, I'm very grateful. I don't propose to go through the great long grass of a lot of those documents or details, but one or two points from the evidence and transcripts at an early stage I'll take you to, but that probably only take 10 or 15 minutes to do, just to set a context.
And could you clarify for us, what are you asking us to do?
We're asking you to find that there were breaches of contract and of fiduciary duty.
Yeah.
And we're asking you to find that the judge was wrong not to grant a springboard injunction, and also wrong not to grant an injunction to enforce 13.1 of the restrictive covenants. If you find that, then we would ask that the matter go back to first instance to deal with any questions of damages, which were never intended to form part of that first liability trial.
Right. So do I understand from that you are not now asking for an injunction?
I can't realistically now ask for it.
Because your appellant's notice does.
I think that was probably in the context of hoping we might have got on a little sooner than
Right.
once.
All right, so you're not asking for an injunction. And you want this to go back to the court at first instance to
Deal with damages.
deal with damages. And am I right in thinking that there are two pleaded heads of damage? One is what you paid these two defendants while they were still employed. And the other is what you say is reputational damage. Is that right?
That's what's pleaded so far.
Was there anything else?
Not at this stage, no, but I merely make the point that if we are successful on the breaches and matters do go back, our position is that we may well wish, when we get back to first instance, to consider amending the pleadings, but that's a matter at first instance. There have been, I don't want to give evidence, my lord, obviously, but there have been developments since June last year when the judgment was given, and those may well tell in damages, and we would make appropriate applications at the time. I can give you a flavour of what it is I'm talking about, but so if you wish.
Well, but just let's stick with the claim as pleaded for the moment. What you paid these two gentlemen is not going to be recoverable as damages, is it?
What they were doing was that they were being paid in circumstances where they were not acting in accordance with their obligations under the agreement. So whether it's damages or a mistake of payment in the context of thinking they were due that money when in fact they weren't, perhaps itself requires further reflection.
And I'm struggling with the idea of reputational damage when the big thrust of your case is that all this was done in secret.
Yes. I think this is a game where matters have moved on to such an extent that probably doesn't really feature terribly strongly in terms of a damages head of loss in itself. If I can just very briefly, and I'm conscious I'm doing this on instructions, but just to give you a flavour in order to put this into a context. My instructions are, for example, that as a consequence of things that emerged during the course of the run-up to the trial and the trial itself, and in particular, have in mind the issues relating to the transfer of data from the company to Mr. Blanchfield's own personal email accounts and so forth. That led to quite a significant task in having to deal with the fallout from that and any data breaches. I'm told that as a consequence, the insurance premiums in respect to cybersecurity increased by £60,000 or so the following year. I'm also told that since June, when the judgment was delivered, within a short space of time, 11 new entities came into the market, dealing in particular with what's been described as APP claims, these push payment claims. And I'm also told,
And that you say is attributable to these defendants, is it?
yes, because what I'm told is that in respect of a number, sorry, did I give you a number? 11. I
11.
corrected that because I was given a different figure this morning. Over 20, in fact. And a significant number of that, and I'm afraid I can't give you chapter and verse, but I take specific instructions if you wish them. In respect of a significant number of those, one or both defendants actually act as consultants to those entities.
Are you saying that these are entities owned and controlled by the defendants, or are you just saying these are entities which have independently come into the market and the defendants have approached them and become consultants?
In respect, there's one caveat to it. Yes, is the answer.
Sorry,
that they have to the latter, that they are consultants to these separate entities.
But if these are independent entities who have come into the market quite separately of their own volition, what is it that stops the defendants from approaching them and offering their services as consultants?
Well, that's subject to looking at clause 13.1 in due course of the restrictive covenants and whether an injunction had lasted over that period of time that they've been doing that.
Okay, my problem, speaking entirely for myself, is that I'm struggling to understand these sort of promises or indications you're giving about certain things which might have happened or might not have happened. I'm trying to understand how that relates to.
Well, I'm not fighting my appeal at the moment on those possibilities or eventualities. I was merely addressing the point as regards what do I want. I want the matter to go back to first instance on the basis of this court's findings in my favour if they are, and then I will address the questions of damages and so forth, obviously more fully and with greater articulation and reflecting in any proposed amendments. Based on specific instructions at that time, and we would want to have that fight based on the findings of this court, should they be appropriate to have. And those will be for first instance.
Well, I think if we are to send this back, I think we need to be satisfied there's something that's worth sending back.
Yes, of course. And I hope that I would be able to satisfy you that there is sufficient, and if clearly if the court at first instance thought that there wasn't, then the court at first instance will deal with that.
Yeah.
So, in terms of the representation, I just make this point quickly, just to make the point clear that's probably already clear, is that although there are two defendants, they are represented now by the same counsel and by the same solicitors. In the past, there's been some difference of representation, although at the trial, it was the same counsel, Mr. Gilroy KC, and two different firms of solicitors. But I only stress the position to emphasise what is pretty obvious, which is that there has never been any difference of approach taken by the two defendants, although it's probably fair to say that Mr. Blanchfield was doing a lot of what we might call the legwork between August and the date of resignation on the 10th of January. And Mr. Montaldo was doing less of the direct work himself. There's no suggestion for it. There has never been any suggestion, for example, that a different approach should be taken by the court in respect of each of the two defendants. They didn't. There was no sort of cutthroat defence or anything of that kind. So they stand and fall together, as I understand the position, and I've never seen anything to suggest otherwise. Sorry, I should also have mentioned, you may have seen, and apologies on behalf of everybody for this, that there was quite a lot of heat being generated in relation to the bundles, and in particular, what's being called the unagreed bundle.
Yes.
I hope that I can deal with that quickly because Mr. Baker confirmed to me in an email this morning that any application to reduce the bundles that I've certainly been working from, and I understand that you've been working from, any application is not resisted, and indeed, to use his words, is not vociferously opposed. So rather than waste time on the bundles, subject of course to my Lord's views, I was proposing to proceed and deal with.
Carry on.
Thank you. And then the final introductory point, therefore, just to put the trial into context, you'll have got this chronology already, but the matter moved extremely quickly. The resignation was on the 10th of January. The application for an injunction was made on the 3rd of February. The hearing took place on the 9th of February. And whilst the first indications were that the application was going to be opposed, in fact, undertakings were provided pending a speedy trial. That trial took place in April. The first day was the 6th of April. Unfortunately, that was taken up on interim applications to deal with disclosure and other things, which meant that the trial itself took place over the 11th, 12th, 13th and 14th of April, over 4 days, which was quite a tight time scale schedule to operate with. We then did not have time.
Just to be clear, I'm not sure what we'll get from that, but that's not unusual in cases of this type where you have limited covenants which you're seeking to enforce post departure. In other words, time limited covenants.
Yes, of course.
It sort of almost invariably does require a speedy trial, or else everybody ends up at a trial and you're thinking, well, what's the point?
No, we asked for a speedy trial. No, I wasn't suggesting there was any. We asked for a speedy trial. We were accommodated by the court, and we were given the 4 days. I was merely saying 4 days with the number of witnesses there were and the issues that we had to get through was quite tight. But we got through all the evidence, and you'll have seen from the judgment that the judge made some observations about having to guillotine the parties to get on. We didn't have closing submissions at the end of that process. We then had written closing submissions. I raised the suggestion that the judge might might like to have oral submissions as well, in case any points arose, and he didn't want that. And then the judgment was itself delivered, handed down on the 29th of June last year. So that's the context in which those things arose. In terms of the facts as regards the activities of the defendants, there doesn't really appear to be very much by way of a contest between the parties. We've set out in the skeleton argument for the purposes of this appeal at quite some length the details of the activities that were taking place from about mid-August 2022. Our knowledge stopped on the 20th of January, a few days after they had handed in their resignation notices. The relevance of that date is that's the date that, without any prior notice apparently whatsoever, Deminor, the litigation funder, offered 1.3 million to the defendants. And of course that was during the period of time that they were on garden leave. I should also clarify the point that they handed in their notice on the 10th of January. They were going to work a 6-month period, but on the hearing in February, it was agreed that that would be shortened and that the garden leave period would end on the 13th of April. There would be a 3-month period. So in the midst of resignation and what was going to always be the garden leave period, they were receiving, at least, I'll put it neutrally, I'll come back to it, offers from a litigation funder in relation to proposals. But we've set out in our skeleton at quite some significant length, and I've tried to give you, I hope, useful references to show the various approaches and the nature of the approaches and the discussions that were taking place in respect of professional indemnity insurance, solicitor regulation authority, banking, the formation of the company itself, office accommodation, funders generally, Deminor in particular. I'll perhaps come back to that in a little bit of detail. And then various third-party service providers and providers of case management systems, circulation of business plans.
Circulation?
Of business plans.
I thought the judge found these business plans were never deployed.
I think that's a reference to the funding packs. There's a distinction.
Both, I think.
Well, insofar as...
So when you say circulated...
They were sent, what I meant was they were sent to third parties. For example, they were sent to potential insurance brokers and they were provided to Deminor. You may remember some interesting evidence was given that in respect to the visit to Deminor in October in London. There's been a bit of a running theme of lack of documentation and email chains, but that's probably not going to get me very far today. But insofar as that is concerned, the evidence was that business plans were taken down to Deminor and thrown in the bin on the way back. And Mr. Blanchfield couldn't remember where this bin was or the street and so forth, but he chose, for some reason or other best known to himself, to throw it into the bin. But the point is that the business plans were circulated in that sense. The website, and then various non-disclosure agreements entered into with various third parties, in particular a company called Impact or Claims Expert, Catch, K-A-T-C-H, and Lionfish. And what we sought to do in our skeleton argument is, I've also summarised in paragraph 29 of our skeleton the email traffic from Mr. Blanchfield with his CEL hat on to himself over several months and weeks. And I've set those out in some detail at 29. So I've sought to summarise what we say with those activities at paragraph 30. We have further analysis so far as the Lords are interested. I'll just give you the references. There's a detailed chronology in the core bundle at page 66.
62.
66. There's my earlier analysis of the evidence for the purposes of the trial in the core bundle at page 41. You've got the pleadings, and of course what is significant is you've got the extensive admissions from the defendants as to what they were doing. So, and the judge himself, and I'll take you to this in a little bit more detail in due course, the judge himself sets out areas of common ground between the parties as to what the claimants said the defendants were doing and what the defendants accept that they were doing. So we have, in our submission, a very clear picture of these defendants carrying out, in our submission, extremely extensive acts. And those acts taken together and cumulatively in our submission constitute improper preparatory works for setting up a competing business and amount to a breach of their fiduciary duties and a clear breach of clause 3 of the consultancy agreement. If I could just take you to the consultancy agreement very quickly. It's only a couple of paragraphs. It's in the core bundle, bundle 1, at starts at page 257. Clause 3.1, it's the same for both defendants. This is Mr. Blanchfield. 260, the consultant must not, during the term, carry on or assist in carrying on or be engaged, concerned or interested in any other business or work of any kind which might give rise to a conflict of interest, provided that, etc. And then the relevant restrictive covenant is at 13.1 at page 263. The consultant must not at any time during the restricted period supply, comma, I stress that, supply, comma, or solicit any person with a view to supplying, comma, services that are the same as or similar to and in competition with the services to any client or customer, the client with whom the consultant had material dealings during the course of his consultancy with the client. And 13.5 provides over the page for a further restriction on the scope of that covenant. The above restrictions only apply in respect of the client's, consultants, customers, employers, directors and workers in respect of which the consultant has during the last year of the consultancy been materially responsible or involved.
What are the breaches of that?
Well, the judge found, well, can I deal with it in these stages? Because I'm going to deal with this in more detail. The judge found that clause 13.1 was a valid clause in the sense that it was prima facie enforceable, it was reasonable, it was protecting a legitimate interest. But he said that he wasn't going to enforce it or provide an injunction for two reasons, as I understand it. One, he said, because there's no evidence that anybody's been trying to solicit. And two, he said, and damages would be an adequate remedy. On the latter, of course, this is a negative covenant, and negative covenants would normally be enforced, and one wouldn't get into issues about adequacy of damages, Doherty and Allman, and the more recent case, which Lords will be aware of course, Dermer, Med and Ali, where the Court of Appeal, Lord Justice Males, I think, I don't have this authority, but Lord Justice Males, I think, dealt with Doherty and Allman and made the observation that, first of all, damages are very difficult to assess in the context of these sorts of covenants if they're broken. But secondly, Doherty and Allman still remains good, that the simplest way of holding somebody to their bargain when it's a negative covenant is to enforce the negative covenant. But the judge didn't decided not to enforce or not to grant us an injunction on the 13-1. In addition to those points, as I understand it, because he said he hadn't seen any evidence of any soliciting or attempted soliciting, and therefore he wasn't going to apply an injunction. Now, we say that is, with respect, a somewhat unrealistic approach to take. First of all, it's not very common that one goes to court with a smoking gun as a claimant to say, here's the evidence that he was soliciting Mrs. Jones last week by phoning and asking for her business. What we say is, based on the totality of everything else.
That's not right. Normally that's exactly the sort of evidence that you get, because what normally happens is that identifiable clients suddenly pop up as clients of the employee or director who has walked out of the door.
Yes.
And on disclosure, you get exactly that sort of evidence that they were contacted or because the people searched their servers and find that the contacts had been made whilst they were employed from the company. Yes,
I didn't have, of course, there's a difference though in our submission. This is post-termination and whether or not these post-termination covenants should continue. And we didn't have any evidence.
Sorry, I was picking up your point.
Sorry.
I was trying to pick up your point. You were saying that it was, I think you said it was perfectly not surprising that you didn't have such things, and you don't normally have such things. And I was just saying, actually, certainly in cases I've done, that's exactly why this sort of litigation happens.
Well, we certainly didn't have any direct evidence of that, but what we did have in our submission, it was most obviously more than enough to justify the grant of an injunction along these lines, in circumstances where, although we will quibble a little bit with the judge's analysis, he himself accepted that there was a settled intention to go away and set up in business.
But your business model, your client's business model, is not one that lends itself to, as it were, repeat business from clients in the established sense. This is one of the particular points about this case, which makes it factually perhaps different from many others, which is that often you have an established business with a book of clients who give repeat business to the company. And it's those connections which it's impermissible for a director or employee to seek to misuse, divert, call it what you will, by walking out of the door and setting up down the road. Your client's business isn't of that type at all, is it?
No. Most of the clients are, well, I can't say all of them, but I accept most of the clients are going to be one-off who've had a specific particular complaint.
Yeah,
I accept that.
Can I just ask you a slightly different question, Mr. Tracy? Let us suppose, for argument's sake, that the judge should have applied Doherty and Allman, and he should have granted an injunction. Where does that leave us? You're not asking for an injunction now, you've told us that. So you are now restricted, are you not, to proving some kind of damage from breach of these covenants, which is not pleaded anywhere.
No, it's not pleaded now, but I am, I would say, would be at liberty at least to apply to amend to include these various things, and those can include post issue a claim form.
You could be doing that. You could presented us with a proposed amended pleading. that was the basis you're asking us to refer it back.
Well, I could, but I rather would have assumed that this court would say take those sorts of applications downstairs to first instance, and don't be making applications to amend before.
Not if we're being asked to send it back.
Sorry?
Not if we're being asked to send it back to the first instance judge on the basis of that there will be an amended pleading.
No, I'm asking you to send it back on the basis that there would be a CMC at which these issues would be addressed. Again, I can only speak anecdotally in terms of that is how, in a case of Hook Group number 1, not the last time Hook Group was before this court, there were issues about amendments, and the Master of the Rolls raised questions about the pleadings, and Ian Lord, Justice David Richards as he was, said the thing to do is, if you're going to amend, we're going to remit this back to the CMC, to a CMC at first instance, and you can deal with your amendments then.
There was a pretty clear, I mean, I can't remember the facts of the case, but there was in a sense pretty clear concept of what the amended pleading would look like. In other words, the cause of action, or the connection between the sort of factual assertions that were going to be made and what was sent back. I mean, at the moment, I'm
Didn't entirely feel like that at the,
I'm just struggling at the moment to make the connection between the points that you've just been talking about. For example, client contact taking us to clause 13, and what's actually going to be alleged by way of loss and damage.
I have to confess, I didn't come to fight my amendment application or my damages case at this stage, and I acknowledge there will be more work to be done in terms of formulation of a damages claim, but I'm merely seeking to give you the heads of area that we will be looking
Take
for.
clients, for example, breach of the clause you've just asked us to look at, 13. I mean, my understanding is you won't be able to identify clients which have been lost by your clients, by the claimant's firm, or clients which have been diverted.
I'm not sure that's right with respect to there are incredibly complex marketing tools that are used to promote these services that are put out, and I'm sure that a detailed forensic analysis of what's being done to gather clients, to keep the clients and so forth, would be able to produce some results which would show.
Well, I must say, Mr. Chasey, speaking entirely for myself, I would be reluctant to send this back to first instance on the off chance that we might come up with some pleadable head of damage if you don't know what they are.
Well, can I come back to damages, my lord? Because there are some passages in the judgment which deal with this as well, and I've already identified, it might not be very high, but I have already identified that there is potential loss in respect of the impact of the cost of insurance.
Yes, you've told us that.
And I would merely make the point that if we have some damages claims, then they ought to go back, whether they're hundreds of thousands or millions, or whether they're relatively modest, is a matter for elsewhere.
How would you tie that to the clause, for example, about clause 13?
No, I wasn't. No, sorry, I wasn't seeking to tie the insurance element. That would be a breach of the fiduciary duties point. I wasn't trying to tie that to 13.1. I'll perhaps make that clear if I may.
I am struggling with the 13.1 in the context of your client's business model and your acceptance that it doesn't, perhaps save in unusual circumstances, have repeat clients.
The point I was making about insurance, though, wasn't a 13.
No, but
I take my lord's point, if I put it that way.
Could I ask just to understand the terms? Clause 13.1 applies to the restricted period, which is a period of 12 months after the termination of the agreement.
Yes.
The termination of the agreement would have been 6 months.
Yes.
But the parties agreed, did they, that it would be terminated after 3 months?
Yes.
So the restricted period was to run then
Yes.
for 12 months after 3 months.
To April 24.
And the judge's finding in relation to settled intention was that their settled intention formed in about December 22
Yes.
was that they would start trading at the end of the termination of their.
Yes, that's what he found. We have quite a lot to say about this concept of settled
I
intention.
just want to get the timing right.
Yeah.
So, but he had in mind when he said that, not the 3 months, but obviously the 6
Oh.
months.
I can't answer for him on that, I'm afraid. I
must
think he
be-
had in mind termination.
Well,
of
he
the agreement.
says that their intention was to serve out their notice until July 23.
Yes, but it was all. But in February, it was all agreed that actually that was going to run to. It was going to be truncated down to April.
Yes,
'cause
but
that's
the
only-
judge was looking at the position, as I understand it, as at January.
Oh, I see. Sorry.
When
Yes.
they resigned as directors, the judge found that their intention was to work out their notice until July 2023.
Yes. Yes, we've got some comments about that, obviously, but yes, that's what he said.
Yeah.
We've got some comments on the other evidence that he seemed to disregard in appearing to reach that conclusion, and we also have some issues to raise about this notion of settled intention, because he seems to have used this notion of settled intention as being a threshold that had to be met before one could determine that their actions amounted to a breach of fiduciary duty, which perhaps I can come back to in a few moments, because it's a difficult matter in some senses to grapple with. If what you're doing is you're acting in contemplation or anticipation, even if you've not got, quote, a settled intention, but you're keeping all your options open. But I'll come back to that if I may. Can I say, I was going to take you, if I may, just to a few passages as regards this point about settled intention and what it is they said in their evidence, and indeed what their counsel, Mr. Gilroy, was advocating in his cross-examination of my clients. If I could ask you to look at just a few, I will try to jump around as little as possible in the bundles, but if I could ask you to look, please, at the supplemental, what I'm going to call the supplemental bundle at page, it's 698. There are some various extracts from the transcript. This is one at 698. This is my client, Mr. Hampson. This is Mr. Hampson, a director of CL, being cross-examined by Mr. Gilroy on behalf of the defendants. And at 698, you can see at line 6, sorry, just above that, Mr. Hampson had said, why would you pay, line 4, why would you pay for insurance if you weren't going to trade? It's expensive. Which Mr. Gilroy replied with an answer, because what you would do is you'd act responsibly and with appropriate caution and make sure that you had, if you will forgive the expression, your ducks in a row. Before you launched, make sure it's all set up. It doesn't mean to say you're going to suddenly start trading whilst you're still a consultant to this, does it? No. But what he was saying to the court was that his clients wanted to have all their ducks in a row so that they could trade immediately on leaving CEL. And the evidence from the defendants is to the same effect and consistent with that. There's another short passage from Mr. Gilroy in questioning at 778. This is in the context of secrecy. And again, he was putting it forward almost as a virtue. At line 6, at 778, he was taken to an email. And this email, for your reference, is dated the 4th of November, 2022. This is ETI Cloud. I jump ahead of myself. And there's a quotation from the email. Ask ETI Cloud for a quotation. And the words in the pleading are, ask for discretion on its part. Okay, so you'll find it at, it's 1900, an email from Mr. Blanchfield. And then there's a question in reverse order. Asking for discretion it's entirely understandable he'd ask for discretion, isn't it? Because he was preparing to go into business. And therefore he wasn't advertising it, walking around with a placard saying that he was going to do so. So it's normal business for him to ask for discretion, isn't it? So he was putting it to the court that his client's intentions and why they deliberately asked for discretion was because they were preparing on the 4th of November 22 to go into business, and they didn't want to advertise the fact or let people know.
What evidential value is a question asked by counsel?
Well, it comes on because you will see in due course that Mr. Blanchfield agrees with his counsel. So that's just to set what Mr. Gilroy was advocating on behalf of his clients, and that's the way in which the case was being presented, and what my clients were being asked to deal with and to answer in the cross-examination of them. And then if you look at the supplemental bundle 4, you can see that phrase "ducks in a row" seems to have resonated with Mr. Blanchfield. 2641. At 2641, towards the top at page 201, the internal page 201, you've told the line 5, you've told the SRA January, you've told it ETI January, and you've told your insurance broker. This is in the context of saying they wanted to go live in January. Yes, I was trying again. I was just trying to bring everything into line, get, all the ducks in a row, essentially. Obviously, people require dates, and if I'd said we're looking to be live in August next year, no one's really going to engage with me. When you say all the ducks in a row, what you mean is everything that you needed to do and sorted in order to set up in business. Well, the preliminary steps to get the license, yes. And
so what's the point you're making? Is this a timing point?
yeah, it's well,
so,
it's
so where, obviously I can see there's a mention of being live in August, and him saying, well, if we were only going to go live in August, no one's going to engage with me. It's too soon. I'm not sure quite what I get from that to relate to your point about it's settlement intention and the notice, which is how we got into this.
Well, I'm merely seeking to show you some evidence that shows that there is no real proper basis to say that any settled intention was only formed at the end of December or early January. But furthermore, what you can see from these extracts that I'm taking you to is that there was this intention and deliberate exercise to get everything done so that almost immediately, once they were released, they were ready to go. They went the next day. So they finished on a Monday, they started on a new business on a Tuesday.
But this particular passage that you've just pointed out to us on page 2641 is addressing events in January.
Yes, this is in the context of I was seeking to make the point through cross-examination and to test the point that because so much of the documentation, and we've dealt with this in my skeleton argument. I've given you all the references under, for example, contacts with insurance brokers, contacts with SRA. All the talk is in the emails of going live in January, not going live 6 months after the notice period, but going live in January. That's
how does this passage that you've just referred us to help you on that? Because at most, what is being accepted by Mr. Blanchard, who's being cross-examined here?
This is Mr. Blanchfield.
Is saying, well, the preliminary steps to get the license, yes, in January.
I think the passage I want to stress, and I'm sorry if I've not made it clear, is his acceptance that what he was trying to do was get all his ducks in a row, get all the prep work done, so that he would be ready to go.
But he doesn't accept that. He just says, well, the preliminary steps to get the license.
He introduced the words ducks in a row, and I said, what do you mean get everything sorted? and he says the preliminary steps to get the licence. That he just mentioned the licence, but I don't think from that evidence it can be suggested that he was ignoring everything else he was doing at the same time.
But how does this help? Because when we know what they did,
Yes,
so we can form.
I'm trying to deal
view
in
as to-
advance with this settled intention point. First of all, to show that the settled intention. This wasn't the judge seems to have approached this as if up until the end of December or early January, all this extensive, detailed work, setting up a bank account, negotiating with third parties, entering into NDAs with various third parties. The company actually, to that extent, operating and trading. It had a live bank account. It was using the bank account.
So trading with whom?
Well, with the website designer. It was paying the website designer, a company called Fiverr, which again we've set out in detail.
But the only thing that went into the company's bank account were the consultancy fees.
Yes, there was no income. I accept that. There's no trading income. But what it was doing was it was doing all of these preparatory works, all of these things. Can I take you to another passage which might better make my point in terms of what I'm trying to labour here? If you look at 2592. At the bottom, at internal page 6, at line 13, I said, when did you intend to start up in business, do you say? From the time of leaving CEL, when did you intend that new business would start? I think the licence would have been issued from the SRA. That would have allowed me then to carry out the activities, which would have been the date that I was then the co-founder of that firm. Just give me a date and a month. Well, it would have been, when did you intend to start up in business? It would have been the date that I'd fully relinquished all responsibilities and stepped away. So what, the 11th of January? No, I gave 6 months notice, so it had been 6 months from the 11th of January. So 6 months after your notice, when your contract came to an end with that 6 months, you would intend to start work the next day in your new business, around that time. Right, so within a week of your contract coming to an end, you would start in business. That was the plan, yes. And we say that admission, that acceptance, makes our point for us. What he wanted to do was be absolutely ready, then effectively the next, resigns on the Monday, starts on the Tuesday, and that's not something.
Well, wait a minute. We've got to keep two points in separately. He ceased to be a director in January. I think that's right, isn't it? Thereafter, he was a consultant employee, but no longer a director.
Yes.
So his directorial fiduciary duties ended in January. He may have had analogous duties in his capacity as employee, which may or may not be the same.
Yes.
But you're talking here, he's talking here about what happens when his consultancy agreement expires, having already resigned as a director.
I accept that. Yeah.
I thought there was self-employed consultants.
Consultant, yes. Yes.
They're not employees.
Not employed, but he's got his duty, he's got his express contractual obligations. But my point is that a director stroke, somebody subject to these contractual obligations, is going too far when what they're doing is getting everything in place to start the next day. Because it's one thing for
let's put to you, it's not starting the next day. That's exactly the point that's just been put to you.
Sorry.
The director's directorial responsibilities, save perhaps in relation to any diversion of identified corporate opportunities, which I don't think is this case, ceased in January, and he's envisaging here starting work 6 months later. Now,
yes.
What's wrong as a director, as a directorial, just focusing on the director, assume there was no consultancy at all. The director ceases to owe his duties in January. There's no maturing business opportunity which is being diverted. and he waits 6 months and then starts up a new business.
Well, he's still
Starts up in new business,
Yeah.
I should say.
What he's
What's
still
wrong with that?
well, he is still, of course, during the time that he was a director, we would say accelerated the process. So if he'd waited until the 11th of January to start any of these things, he'd have been pushed back. But his objective during the time that he was as a director, he didn't wait. He chose himself deliberately while he was a director to do all of these things with the intention and pure objective so that he could, the day after he ceased being paid by CEL and his contractual obligations subject to the covenants, his contractual obligations also came to an end, to go straight off the mark, an absolute running start in terms of his position.
Because you're trying to put together, as I understand it, and I think that's what my lord was putting to you, you're trying to sort of mix and match two sets of obligations. One is the fiduciary obligation of the director, and the other is a contractual duty of a consultant or employee, and add the two together and reach a different result than you would get if you applied either individually.
I suspect the reason I'm falling into that error is because really his contractual obligation is effectively the same as his fiduciary obligation, which is not to put himself in a position of conflict during that period. And it just cannot be right in our submission that for the 5 months while you're a director, you're getting all your ducks in a row, to use his phrase. You then you resign, you choose to resign, you then carry on receiving your consultancy fees for the remainder of the term while you're still subject to your contractual obligations, so that all this is done so that the day you stop being paid, or rather the next day, you've got an oven ready company, business set to go, set up, open the shop. That's what we say is the difficulty with it. And that's where we say they've gone too far. So we've got other short passages in terms of these admissions. So at page 2593 at the bottom, I raised this point that Mr. Gilroy had put about
Which internal page?
2593 internal 12 at the bottom.
Internal 12, yeah.
Line 22. Mr. Gilroy said, I put to Mr. Blanchfield, Mr. Gilroy said, because he was preparing to go into business, he wasn't advertising it, walking around with a placard saying what he was going to do. It's normal business for him to ask for discretion, isn't it? I assume you agree with Mr. Gilroy's analysis of what you were doing, which was preparing to go into business. Yes. Thank you.
Sorry, I'm just missing where it is in the. Sorry.
So it's the bottom of page 2593, internal 12, line 22.
Sorry, I misheard it.
Sorry, bottom right-hand corner. I put that point that I drew your attention to, Mr. Gilroy's question to my client. And then over the page at 2594, I said, I assume you agree with that. You were preparing to go into business. And the answer is yes. And that, for what it's worth, there are so many others, but for what it's worth, that was that was that was the 4th of November 22. That particular email that Mr. Gilroy alighted upon. And I took him to that area of cross-examination. And Mr. Blanchfield accepted that at that time he was preparing to go into business.
Forgive me, but if you set up a company and you are then taking steps to obtain insurance and set up a bank account, you're self-evidently preparing to go into business.
Yes, I don't. But that's you're not. That our submission is that they went too far. The steps that they were taking on that Shepherd's Investments band, talking to a friend in the pub, I've got this idea of setting up a business, and actively soliciting or diverting a business opportunity. Those are the two extremes. In the middle, of course, there's a vast potential array of possibilities. And what we say is that the facts of this case, the extreme nature of what was being done in this case are at the right-hand end of that band. In other words, the non-legitimate steps. So, because if they're not,
Can I go back to the? Maybe you're going to get to this, but can I just ask the question? Is that band and where somebody may land on it the same for an employee as a director?
it's easier to prove it being met for a director. I think that's what the authorities would say, on the basis that an employee wouldn't have strict fiduciary duties. But in this instance, it's the same, I say, for the reasons I've already said, that the contractual obligations and the fiduciary obligations are the same for these two individuals.
So if they're the same, we look at them as if they were employees or consultants.
No, they've got their consultants, but they've got their express contractual obligations not to do anything that might conflict. And in our submission, it's self-evident. Sorry.
So in fact, are you saying they could do nothing by way of preparation whilst they remain directors?
Consultants, for that matter.
Or consultants?
Consultants.
Sorry, yeah.
One goes back to this band. I can't. It would be silly for me to say they can't do anything. They could walk around the street and say to themselves, "That looks a nice office block."
Could they, for example, acquire an off-the-shelf company which remained entirely dormant? They just acquired it.
My first reaction is say probably yes. Probably they could do that if they just create a company.
So they can open a bank account in the name of the company and which remains entirely dormant.
Well, then you're starting to where it crosses the line in our submission is when you have done sufficient things so that you're ready to go virtually straight away. You're clearly not acting either in the best.
But they're not ready to go straight away as directors. You see, what you're doing is you're putting them into the category of directors for the purpose of saying what they can and can't do, but then ignoring the fact that their intention was not to go straight away, but to work out a period of notice, contractual notice.
Well, I don't want to lose my contractual obligation arguments. Those in our submission are strong, solid arguments. I've already tried, I think, to address the question of the director's position, which is that, again, it's our submission that they can't use their last 5 months of their office of directors to be doing all of this preparatory work either. And the fact that they might have waited, and if they'd left it until February, that might have been different, doesn't in our submission negative what it was that they were doing while they were directors. It doesn't stop them having been in breach during that period of time. One's got to, in our submission, look at the acts that they were actually doing. And just for the sake of argument, I take my lord's point entirely that there was a gap. But if, for example, there wasn't going to be a gap, if they were doing all of the work with the intention of starting the day after they left and we didn't have this 6-month issue, in our submission it would be self-evidently a breach of fiduciary duties. In our submission it couldn't conceivably be proper for a director to set himself up so that he is ready to start the very next day. A company with its directors might have to live with the fact that directors are free to leave. Of course they are. They don't have a fiduciary obligation not to leave the company. They can resign if they choose to resign. But a company would be entitled to expect that those directors haven't, in the period of time while they were still directors, engineered themselves into a position where it's seamless, where there's no gap at all.
In circumstances where there is no suggestion of diversion of clients, and no specific criticism of lack of attention to the business of the to the business of the company of which they were director.
Yes.
So you're saying that just as a matter of law, a director cannot take any preparatory steps which allow him to start a competing business the next day he resigns as director.
That's what I say, and I have some support. In the case of Berryland that I referred to, is Honour Judge Hodge, where he set out 5, and I've quoted this in our skeleton just to remind them.
What I'm trying to do, and I don't want to take you out of your way, is I'm trying to just get my bearings. When you ask us to look at facts as to what you are saying the legal framework
Yes.
is.
Yes.
I'm just struggling at the moment with exactly what you're saying the legal framework is.
Well, what I'm saying the legal framework is it's a breach of duty to act in such a manner that the vast majority of the preparatory work, which we say is the case here, has been completed during the time that you were a director. That is a breach of your duties.
Which of the duties of the director is it a breach of?
Well, it's a breach of your duty to promote the success of the company, because that's not, when you're doing those things, what you're remotely seeking to do. You're seeking to actually engineer a position where sooner rather than later, if you had not done those things, the company will be facing competition from you and your third part and your company. And it's a breach of your duty, similar point, it's a breach of your duty not to put yourself in a position of conflict or in a position where your interests might conflict.
So is this right? You're saying on the first of those. So is it you accept that the director, that nobody can be exposed to, nobody can prevent competition. A company can't prevent it.
Not in the absence of an enforceable restrictive covenant.
So you say a director, it's not in the best interest of the company to whom the director owes his obligations for him to prepare to compete the day after he resigns. There has to be a reasonable period, or just do nothing. That's what I'm trying to understand. What the actual contention is.
Others better than me have struggled to articulate the test, and it's difficult to articulate a test. I think, as Lord Justice Rick said in Foster, it is a fact-sensitive scenario. So, not that there are any facts in dispute here. It's easier to identify what's wrong rather than necessarily to, in advance, anticipate. That's why I think I'm struggling to answer my Lord's question in a couple of sentences. But creating what will be an entirely dormant company effectively achieves nothing in terms of time. It takes 10 minutes to set up the company, and that makes little difference. But all of these approaches over a long period of time to build up further relationship, for example, with insurance brokers, to go through the process of discussion, what is it you want, how much do you want to spend, all of that kind of process, to deal with the website, to get that into shape, to do all the tweaking and so forth that inevitably involves. And most importantly, of course, the negotiations with the funders. I've not stressed those enough, perhaps, yet, and I would like, if I may, to come to Devinor. This took place over a significant period of time. These things that you don't just buy off the shelf, or you don't just walk around and look at an office block and say, that looks nice, and I'll remember that for the future. The things that we're complaining about here, and the level of the preparatory work, is in our submission a million miles away from the left-hand extreme, as it were, that's postulated in Shepherd Investments. And it is a question of where do you draw the line?
So on the one hand, it's the balance. I've written down not in the interest of the company to face competition as soon as the director resigns. So you say it's a breach of the duty to act in the best interests of the company.
Yes.
The best interest of the company is never to face the competition, right?
Yeah.
But
Quite.
You have to accept that has to be moderated in some way in this area, because it's understood that companies can't forever insulate themselves from competition. So I'm struggling to
those are not
why you accept, for example, that a director can do anything before he resigns.
Well, perhaps I shouldn't have made that concession, but common sense dictates that the 2 points that my Lord's articulate are not mutually exclusive, in the sense that it's a question of marrying those two competing tensions together.
But I'm just trying to understand how you say we should marry it.
As I say, others better than me have tried to articulate a test, and they've not
That wishes to be
succeeded.
funny, or otherwise, you're the best we've got at the moment. So do you want to give us your best shot?
Well, the best shot is really almost, I think, what His Honour Judge Hodge was saying, and that is, and again, it might require further refinement, but what he said, and this is my quotation at paragraph 45 of my skeleton, is he said, the law regards it as unlawful to undertake the following: taking the necessary steps to establish a competing business so that it's up and running or ready to go as soon as the employee leaves his employment.
Which law is he talking about?
He's talking about fiduciary obligations.
Talking about directors there.
I believe he is. I might want to just cross-reference that.
Can you just tell? Yes, I mean, sorry, without taking from your skeleton, which you,
Give
us the authority.
Yeah, it's in the authorities bundle at tab 7. So that is in bundle 1. I should add this slight note of caution that the decision of His Honour Judge Hodge was overturned on appeal, but on completely separate points. If I can just explain that, I don't have the appeal case. It's at page 328 of bundle 1. It was overturned because the case involved issues of conspiracy, and the Court of Appeal felt that the distinction of the two defendants in terms of their defence to the conspiracy charge had not been fully explored. One of them was a litigant in person, and arguments that might have been advanced had not been advanced, and therefore, to that extent, it was overturned. But if you look, please, at page 341, at paragraph 21, His Honour Judge Hodge said, happily the law itself, as distinct from its application to the facts, is largely non-controversial. And then you can see that he was referred to various authorities, some of which we've got in the bundles. Item Software, Helmet Integrated, which we've got in the bundle, Shepherd Investments, which we've got in the bundle, Attorney General and MIA, and so forth. And then at 22, he says, a director such as Indiran is subject to a fundamental duty of loyalty which requires him to act in what in good faith considers to be the best interests of his company. He shouldn't undermine the company of which he's a director by competing with it. It's contrary to his duty of loyalty for a director to act, and then there are 5 points, I'll go through them, act contrary to the best interests of his company, seek to make a profit for himself through the use of his company's assets, information, or maturing business opportunities, solicit or procure his existing company staff to work for his new company. Employees such as Helen and Sophie are subject to a duty of fidelity, which requires them as employees to be loyal to their employer and to act in good faith. And then he goes on to deal with the distinction between employment. And then at 23, he says, I'm satisfied from the authorities that when drawing the line between legitimate preparation for future competition and undertaking illegitimate competitive activity before an employee has left his employment, so he does talk about employment in this scenario, the law regards it as unlawful to undertake the following: working for a competitor while employed, personally competing while employed, concealing or diverting matured or maturing business opportunities, misusing the employer's property, including confidential information, and 5, and this is my part, taking the steps necessary to establish a competing business so that it's up and running or ready to go as soon as the employee leaves his employment.
And so, despite what you told us a little earlier, what the judge is talking about here are employees, not directors.
That seems to be correct, yes, because he starts talking about a director at 22, and then he goes on at 23 to talk about.
Well, you presumably would say, well, directors are not conventionally thought to be under any lesser obligation, fiduciary obligation than employees. But where does he get Where does it get that from?
Well, I read through at 21. I went through all of those authorities and all the references that he referred to, and I think it's fair to say, and I have to say and make it clear, that I couldn't find. It wasn't as if he was quoting, I think, a specific passage from any one of those authorities to deal with what he says at 23. What I think he's done is he's taken, if you like, the themes and the principles that he interpreted he could take from those authorities, which culminated in his summary of the law at 23.
Wouldn't it depend on the business, what kind of business it is? I mean, I'm employed as a window cleaner and I want to set up on my own. Well, I've got my ladder and my bucket and some soap. Why shouldn't I start the next day?
Again, there's always an opportunity to use an example such as that, but buying his bucket and spade, it would take him 10 minutes to buy his bucket and spade. He's not doing anything sophisticated or exceptional there, but because he could have done that the next day on his way to his first job. These defendants couldn't have opened the shop ready for business the next day without having done all of these things that took them weeks and months. I think that's the point.
Isn't there another way of looking at this, which is that setting up a new company, obtaining its bank account, applying for it to be licensed by the SRA, obtaining funding, etc., are all steps which could perfectly properly have been taken on behalf of the claimant. Setting up another parallel business for it, another maturing opportunity for the claimant. What the defendants were obliged to do as directors was, if they were going to do those things, to do them on behalf of the claimant. What they were not entitled to do was to do it on their own behalf.
Yeah. And
you can regard complex claims as a maturing business opportunity.
Not for the claimant.
Why not?
Well, the claimant. There's no suggestion ever that the claimant was going to benefit from these activities.
But it was an opportunity, was it not?
Oh, sorry.
Which, if they were going to exploit it, they were obliged to exploit.
Sorry, I misunderstood what you were saying. Yes, in the same way of Deminor, which I want to come on to. They were absolutely, in our submission, centrally in breach of their obligations in respect of Deminor.
I mean, if they'd gone to the claimant and said, look, we've got a really good idea of setting up another business called Complex Claims, and we think we can get funding from Deminor to do it. And the claimants have said, what a very good idea, yes please. All of that would have been perfectly above board and would have been on behalf of the claimant.
Yeah.
Now, does the fact that they did it secretly, not on behalf of the claimant, mean that they're absolved from any breach of fiduciary duty? I'd have thought the answer to that is fairly evidently not.
Right, the opposite. It exacerbates the position, and that's exactly what they were doing with Deminor. I said I'd like to develop Deminor a little bit more. Could I just try, just in order to develop that point, that theme that my lord's making? In respect of Deminor, can I just set the scene quite briefly?
Just to pick up that exchange between my lord and yourself, I think it does follow from my lord's proposition to you that they could do nothing by way of preparation whilst they remain directors. That's the logic of my lord's point.
Yeah.
Well, I don't know. Does it? I think they can do They can do things which don't amount to. Which wouldn't amount to an asset or an opportunity of the claimant. I mean, for example, if they merely incorporated a company, which anyone could do at any time. The fact that they may intend in due course that might be the vehicle for competing business doesn't seem to me that would amount to an asset or opportunity of the claimant. But once they take that company and they start to turn it into a business opportunity, by giving it a name and a website and a registration and seek funding for it, at that point it is very much a business opportunity. And that business opportunity is owned by the claimant.
And well, and in particular, I'm sorry to keep harking back to Deminor, in particular, in the context of Deminor, if I could just set the scene on that, my lord, to develop that point. Deminor, as my lords will have gathered from this is not controversial, I'm not giving evidence, I'm just reciting what the position was. Deminor was one of 4 funders that were extremely interested in doing business with the claimant. There was something of a competition between the 4 of them. In the end, a company called Augusta succeeded in attracting the favour of the claimant, and Deminor lost out. But those 2 and 2 other companies, one of which is called RPL Funding, and another, the name of which I've temporarily forgotten, were all extremely interested.
But once your client's company has decided to go with somebody else, Augusta, I think it was, not Deminor, why does it continue to be any form of maturing or other business opportunity? I mean, it's fairly basic. I mean, if the company has clearly decided not to go for a particular
we put it in this
business venture or otherwise, I think it's Piso Silver Mines from memory, then why is it any longer a maturing business opportunity? It couldn't.
It's not so much a maturing business opportunity, it's a risk of conflict and potential damage, and therefore not taking into account
now you're
the
mixing,
interest.
But now you're mixing and matching.
Sorry, I wasn't trying to. Sorry, I wasn't trying to. I've taken the maturing business opportunity point. I simply wanted to develop on a similar theme, but I set not exactly the same point as a business opportunity, but to show the manner in which they were not acting in the best interests of the company.
So you're now not treating Deminor as an example of a maturing business opportunity?
No, not in that sense. No, I'm not.
I thought it was quite clear on the authorities, we haven't looked at them, that a maturing business opportunity doesn't have to be one that the claimant was aware of, wanted to pursue, or even could pursue. If it was nevertheless a maturing business opportunity which the directors are pursuing, they're obliged to pursue it for the claimant.
And I'm sorry, it's easier on the facts, my lord, if I could just make the point, and I think it will become clearer to you what I'm striving to demonstrate. Insofar as Deminor is concerned, if you would look at page 2559 of bundle 4. At page 2559 is a board resolution of the appellant. Unfortunately, so it's the 28th of April 2022. And you can see at the top it says, pursuant to the articles, Paul Hampson, Jessica Hampson, Mark Montalvo, Thomas Blanchfield, together with the board, following a meeting on the 28th of April, note and resolve as follows. And then it's number 2, approve external funding for the fraud department. The directors noted their statutory duties, and in particular their duty under 172 to act in a way in good faith and most likely promote. The directors received external offers of funding to promote the growth and expansion of the fraud department from 4 different legal case practice funders, namely PRL, Ampler, Deminor and Augusta Ventures. The funders were approached in December 21 and January 22, and a process of due diligence was carried out, with all 4 offering finance. Funding offers for both recourse and non-recourse were received. After consideration of all offers, it was agreed to accept the terms put forward by Augusta via their Augusta Pool 3 Limited for non-recourse with a facility of up to 40 million in tranches of 4 million, etc. So they went with Augusta. The evidence is very clear. There is no controversy. I could give you references if you want them, that both defendants were heavily and intimately involved in the discussions with all four funders, including Deminor. The document at 2561 is an extract from the funding agreement with Augusta. And you can see at 17 it says events of default. And one of the events of default, and this is something that we stressed at the trial, one of the events of default is 2564 is clause 17.15, key man. Any of the managers cease, and that includes the term managers, includes the defendants. Any of the managers cease to be a director of the target CEL, or to devote the time and attention to business or trade of the target required to enable the target to carry on its business. So the mere resignation of either of the two defendants could trigger an event default. That could have meant, theoretically at least, could mean that Augusta could have withdrawn from the funding agreement.
What are you saying, that it's a fiduciary duty of the directors that they have to remain directors?
No. What was going on though at the time was that they were keeping deliberately secret and lying, and again I can show you this, in our submission it's right to describe them as lies. They were keeping secret from CEL the fact that they were in heavy negotiations with Deminor. They lied when they went to a meeting in Brussels.
On October, at what time?
There were two meetings that we know of with Deminor. One was on the 5th of October.
Yeah, so this is a board resolution on the 28th of April 2022.
Yes, so my point is, they'd gone on the 28th of April with Deminor, with Augusta. Okay, they had Deminor knocking on their door, but they chose to go with somebody else. CEL, I mean. What the document I've got at 2561 and 2564 is the events of default of the Augusta funding agreement.
What was the date of that?
I'd have to check. I think it's probably May or June, but I'd need to check that. What CEL was at risk of, at least theoretically at risk of, is if either or both of the defendants left, under 1715, Augusta might theoretically use that as an excuse, if for some reason the relationship was in that state of play at the time, to call in the funding.
Yes, but hence my question. Are you saying that once the CEL had entered into the Augusta agreement containing this clause, the directors, in accordance with their fiduciary duties, were unable to resign?
No, I'm not saying.
Okay, so you accept that.
I accept that.
Then you started to say, yes, but look, when they're on the one hand committing CEL to enter into this agreement containing this clause in April, what, they were lying because
No, I'm not sorry. I'm not being very clear. The timeline is April 22, they have the board meeting and they choose who to go with. And up to that time, the defendants have been intimately involved and closely involved with the negotiation with all four of them. So they've got personal contacts, they know people. Whatever the date is, May or June that year, they then enter into the, CEL then enters into this Augusta funding agreement. What then happens though is completely unknown to CEL. The defendants start preparation and get heavily involved with Deminor, with a view to taking Deminor out of the market, we say, in all practical terms. Deminor wants to fund in Europe and in the UK, and the defendants wanted it to fund their new company. If all that's going on, and CEL doesn't know anything about it, and they deliberately withhold it from CEL, CEL is in a very precarious position, we say. At any moment, they could find out that Augusta wants to, for whatever reason, terminate under 1715. CEL goes and knocks on the door of Deminor and finds out for the first time that Deminor's got into bed with the defendants. So that great interest that they had with CEL in the past. So it does go, in a sense, to this business potential opportunity, or at least it creates risk for CEL. And those are the points that we were seeking to stress before the judge at first instance. And to compound matters, there were misleading. The defendants did mislead, putting it at its lightest, the company CEO in respect to their dealings with Deminor. Because, again, just to give the facts on this, it's in our skeleton at, forgive me, yes, it's in our skeleton at page 329 of the second core bundle. And you can see at 330, at subparagraph 7, on the 29th of November, Jessica Hampson had asked the defendants to attend a meeting on the 5th of December. And the response that she received from Mr. Montaldo was that he'd planned a holiday trip to Brussels. Now, whether it coincided with a holiday trip to Brussels or not is a matter of debate. But what he didn't say was, I'm going to Brussels in order to talk to Deminor about getting a funding agreement from them. And he misled Jessica Hampson on this. And if my lords would want to see the relevant...
Sorry, your skeleton says the response was that Mr. Montaldo had planned a holiday trip to Brussels, an obvious lie. Why is that an obvious lie?
Because what he was really going to do was go to see Deminor.
I thought you just said you didn't know whether it
the
was
evidence is... Sorry, I'd have to get into the really long grass on this. There was some talk about having booked flights in advance, and then there was some talk about those flights being cancelled, but then taken up by Blanchfield and Montaldo.
But I think if you're going to make allegations about obvious lies, you need to be pretty sure of your ground.
Well, we did submit that they were lies, and we do maintain the position that if you say I'm going on holiday, even if you'd had initially an intention to purely and solely and exclusively go on holiday, but what you then say is, I'm just going on holiday, but actually you decide that you're going to combine that holiday with a business trip and that you're going to do it for the purposes of entering to Deminor. To simply say, I'm going on holiday, we would submit in most common parlance that that's a lie, because at best it's a half-truth. But we would say we're entitled to regard that as most people might, that it's not telling the truth. And we asked about this, and Mr. Montaldo sought to justify what he'd done. And I put it to both him, certainly I put it to Mr. Blanchfield, what the reaction would have been. What did he think the reaction would have been? I'll have to find the reference, but I asked him, what do you think the reaction would have been if you told Mr. Hampson that actually you were going to Brussels on the 5th of December to try and negotiate a deal with Deminor for a new business?
But that applies to everything they're doing. The reaction if they've been told that they were setting up another company,
it does.
website, bank accounts, any of that would have had a horrified reaction.
It is. Perhaps this is just the extreme one where actually the opportunity, quite strangely, coincidentally, came up to actually tell the truth, to actually tell what was happening. And they decided that it was in their best interests, not the best interest of CEL, for CEL not to know. And again, that's an obvious, in our submission, breach of an obligation of a director. The director, in circumstances such as these, should realise and should know that he has to tell the company, when he's faced with that kind of opportunity to come clean, what it is he's doing, to at least... It doesn't matter necessarily, but to at least give CEL some chance to get its position protected.
So just to be clear, then, again, I'm just trying to understand the framework. You say once CEL has entered into the agreement with Augusta, which contains a clause that says if a key man leaves, Augusta can terminate. Yeah. When does one of the key men, if he's a director, have to tell CEL, by the way, I'm thinking of leaving, by the way, I had a thought in a pub last night, I might leave, just like to let you know, or where on the line?
I think that's really at the beginning.
Yeah, but so when does when
when
the
he's
obligation kick in?
when
to,
he's
to tell, to quote, come clean, in your words.
well, we're back to this settled intention possibility.
Well,
that's the
why
difficulty.
I'm afraid that's why I'm
Yeah,
trusting
no, I
you.
understand. I understand. Well, he's certainly got to tell them once he's decided he's going to hand in his resignation.
Once he's got a settled intention.
Yeah, whatever that means, because their intentions are ever
Well,
settled.
all you need to say
but-
is
but-
that all you need to say is it was sometime before the 10th of January.
Exactly, that's right.
And at
Because
some point-
it was well known.
Well, the way you put it, as I understand it now, which is to some extent fitting bits of a jigsaw together, is you say that before the 10th of January, they should have warned CEL that they were going to do something which might enable Augusta to terminate, and what is more, they were going to take the other interested funder potentially out of the market.
Yeah.
And you say they owed a fiduciary obligation to the claimants to do that.
Yes, and that's what we stressed both through cross-examination at the trial and to the judge at the trial.
But
And,
really,
and that's why he seems to suggest that Deminor is perhaps a bit more finely balanced, as he.
well, Deminor, according to your skeleton argument, decided in December that they would not proceed.
Yeah.
Then the defendants resign as directors, and then on the 20th of January, Deminor send out this memorandum of understanding. So
Those are
at
the
the
facts.
time of the resignation, the trail with Deminor had gone cold.
Well, the paper trail had gone cold. We had, and you can see from the judgment, but it's not really explored terribly greatly, we had deep concerns and reservations about documentation because a lot of it just did not add up. It didn't stack up in terms of the limited email chains that we had between the defendants and Deminor with so many gaps was really quite extraordinary. And the judge himself made an observation but he didn't then really take it very much further. The judge himself made an observation at, just bear with me to find it, paragraph 188, I think, of his judgment. He says at paragraph 188 in the core bundle at page 101.
Yeah.
He said the main reservation he had in relation to the evidence of Mr. Blanchfield and Mr. Montalvo related to the lack of documentation, correspondence or emails which was disclosed or made available to me in the context of their dealings with Deminor. I'm surprised that more wasn't disclosed. Having expressed surprise doesn't really then feature terribly in terms of any further analysis. But the chronology, to take my Lord's point, is yes, we saw an email saying on the 16th of December, we don't want to go on. And then the next document we see is the 20th of January saying, oh, by the way, we'll give you 1.3 million. But it seems surprising that nothing happens in between. Although we do know from the evidence that they continue to have every 2 weeks they had meetings. They went that far to concede that they continued throughout the period to have meetings every 2 weeks with Deminor. But there are no agendas, there are no notes of the meetings, not a single piece of paperwork is being produced, which caused us to have concerns and reservations of just about these points. So Deminor features in the judgment below and features as a separate point to say that was troubling. But the rejection in our submission in the judgment of the conclusions that we were inviting the judge to reach on Deminor were just not justified. There was and in our respectful submission there was an extraordinary degree of indulgence on the part of the judge as regards this behaviour and activity on the part of these defendants. And we throw all the other points into the mix in terms of the insurance and so forth. And we say we find it very hard to see how, although there is some brief analysis as to support the conclusion, how it can be said that this settled intention was only formed at the beginning of January or possibly late December. Because all the other facts showing from the 20th of August, there's a whole, I'm conscious that there's a limit to the extent to which I can ask you to get into the long grass of all this detail. But again, we've sought to summarise some of these points. There are pages and pages of communication between the defendants by way of WhatsApp messages, which we went through at the trial, which in our submission are entirely indicative of the agreement between the two of them that they're going to get into business. Silly little comments such as, which featured from memory, this time next year, Rodney, an extract from a TV programme, will be millionaires, one would say. Just making these points about what they anticipate 2023 is going to bring and so forth. That all of that evidence, all of the lengthy, detailed communication seems to have been completely put to one side and not given any real weight whatsoever. Well, can I come to this question of settled intention point? Because the judgment, again, I should take you to this. The judgment picks up on this in a couple of different places. So if you go, please, back to the judgment. I'm sorry to jump around. If you go back, please, to the judgment of paragraph 268. Just a couple of paragraphs here. 268. I accept that he would have sent documents and information to his private email address after August. This is talking Mr. Blanchfield. In the course of his work duties at CEL. I've also found that the defendants didn't form a settled intention to leave until December or January 23. Well, even on that analysis, if there was a settled intention to leave at the end of December 2022, bearing in mind what they'd been doing and that they were going to resign their directorships and Deminor, that was the time in our submission to have told CEL what they were doing. We would say the settled intention was actually earlier, but that might not be necessary for my purposes. Just here, it's also an interesting observation at 270. The increased regularity and timing of some of the emails of which CEL complains are such that, in my judgment, the most likely and most credible explanation for the increase in volume of emails to the email address towards the end of his time at CEL is that he wanted to retain access to various documents in case they were of use to him in the future. If he left CEL, such as, for example, documentation about CEL policies and insurance arrangements. Now, they're not allowed to do that. He's not allowed to send himself the company's own internal documentation to use for his own benefit at some later stage. But that just seems to sort of come and go, that observation. But just going back to the settled intention, so 268 is where it first seems to feature. And then at 280, you get into the sorry, I've given you the wrong reference there.
Just staying with the documents point. Yeah. The judge did find at 279 that any documents that Mr. Blanchfield sent himself had been deleted and weren't capable of being used in the future. And that goes to relief, doesn't it? What relief is appropriate.
Yeah. If you then look to see how, sorry, I gave you the wrong reference there. So he then starts to address the law at paragraph 301.
301.
This is where he starts to talk about under the heading the law. And he refers to the statutory obligations. And then He refers, for example, at 313 to Shepherd's Investments and some of the other authorities. Perhaps I should just look at 317. This is possibly the source of the settled intention point. But he says in 317 there's a reference to British Midland Tool, which Shepherd's Investment preferred over Alston and Headline Filters. But the quote that the judge makes from 317 is this: a director would be under a duty to alert his fellow board members to a nascent commercial threat to the future prospects of the company. And that would be all the greater, and certainly no less, when he himself was planning to be part of the threat. A director who wishes to engage in a competing business and not disclose his intentions to the company ought, in my judgment, to resign as soon as his intention has been irrevocably formed and he's launched himself into the actual taking of preparatory steps. But that's possibly where there's this reference to the date of intention or the moment of intention. The judge then, under the heading My Decision, deals with various points, but then at 321, he says, it's evident the steps taken by the defendants to prepare for their new business fall into the middle ground identified in Shepherd's Investments. Their activities go beyond discussing such an idea with friends and family, but don't reach the other end of the spectrum, soliciting customers. The range of activities is fact sensitive. In essence, that means each case turns on its facts.
So just pause a moment. Do you accept the judge is right at 321? Gone beyond casual conversations, but not soliciting customers and not actually competing.
Well, they're not soliciting or actually competing, but that end of the spectrum could have included things that I'm concerned with. They're right. They weren't we have no evidence they were actually soliciting at that time beyond Deminor, if that could be described. They were talking to Deminor.
Deminor's not a business.
No, it's not. No, it's not.
It's a funder.
It's a funder. It's an interested
like a bank account. It's like something you need.
Well, it's a bit more than that in the sense that the funder wants to get in the market and share in the spoils of the business.
Something on your side of the fence. It's not soliciting for business.
No, quite. But it's an integral and necessary part of this kind of business.
So is a bank account.
Yes, but most businesses are not going to have a problem with a bank account. But attracting a litigation funder is clearly a big deal, because a company like this need it. They need that kind of financial backing. The banks don't provide it in the same way that professional litigation funders do.
Yeah, all right. Well, that's 321.
And then 323, it says, in my judgment, a key issue relates to the defendant's intentions and frame of mind when the steps were taken, in particular to when they formed a settled intention to establish their new firm. Now, we respectfully disagree with that. We say that the question is, what were they doing? And what were the potential consequences of what they were doing? Because otherwise, it's difficult to work this out in practice. It seems if they still just had a hope or an expectation, or they wanted to keep their options open, so they were doing all of these things while they were directors. But at that time, you couldn't say they had a settled intention. But then the next day, they did have a settled intention. The judge seems to be afraid of the base. I'll ignore everything that went before they had a settled intention. And in our submission, that can't be right to apply this sort of subjective approach that he seems to be wanting to approach in terms of, well, you're not in breach of implied usury duties as long as you didn't have a settled intention at the time. The question is, were they carrying out legitimate preparatory steps, which, if they'd then chosen to take advantage of those preparatory steps, was improper? That's what we say is our submission.
So the formation of the intention, so to speak, retrospectively means that what they did before the intention was formed is improper.
If you're going to focus on intention as being a trigger, yes.
So this,
But the question is, should you even be focusing on the intention? If you're doing things with a view to making yourself best placed to then make a decision in terms of settling your intention, you're acting in our submission in breach of your fiduciary duties.
So if you go for a job interview, haven't decided whether to leave or not, but
Again, I accept that there are some at the very end of the extreme, but this is not that case. This is setting up in competition, not
but
just
I'm
going
sorry, I
to.
thought your point was intention doesn't matter.
Sorry, if your intention is to go and work, just go and get a job somewhere, then to that extent intention matters. But what I'm talking about here is in the context of what we know are the parameters here. This is to preparatory works to set up a competing business. And I say it's not clear with respect where the judge drew the threshold, as he seems to have applied, of needing to look for a settled intention, or the authority that he's relied upon in order to say that that concept, if you like, is a key issue. At best, I think there was a reference, as I say, at 317, paragraph 317 to the British Midland Tool, where Mr. Justice Hart said, if you've got an irrevocable intention to go, you should tell somebody. But that's not quite the same point that we're dealing with here.
but I think you are saying that Mr. Justice Falconer was wrong in
Yes.
Bolston, and you're also saying Mr. Justice Hart was wrong in British Midland Tool.
I'm saying Mr. Justice Falconer was wrong in Bolston and Headline, essentially for the reasons that the Master of the Rolls said in Shepherd's Investments when he looks at those two authorities.
But I think you're also saying, but I think you're also saying that British Midland Tool is wrong.
I'm not sure that I need to do that because I would accept that certainly once you've formed an irrevocable intention in the way that Mr. Justice Hart describes.
Your
You should do
point
that.
is that irrevocable intention is not, or whether you use the word irrevocable
quite.
or settled doesn't matter.
Quite. Yes, I am.
You're saying that is not the test. So you're saying, so to the extent that that's what Mr. Justice Hart was saying,
Well,
he was wrong.
Well,
I'm just
if he's
I'm not saying you're wrong.
If Mr. Justice Hart was saying those are the only circumstances in which you should do that, then I would say he was wrong. But I'm not sure if that is what he's.
I think you have to read what Mr. Justice Hart said in its full context. And he is starting, as I think must be right, that this comes from the director's duty to alert his fellow board members to a nascent commercial threat.
Exactly.
So what he is saying is that once you are going to reach the stage where what you are doing amounts to a nascent commercial threat, you have to resign to avoid being in breach of fiduciary duty. Because thereafter, if you haven't resigned by that point, thereafter what you do is a breach of fiduciary duty. So the key is it a nascent commercial threat? Not. And what Mr. Justice Hart is saying is that he thinks that would be where there's where an intention is irrevocably performed and actual preparatory steps.
Yeah.
But what that doesn't identify is what's the case if you've launched yourself into actual preparatory steps whilst perhaps retaining a locus
Well, you
that
should.
you might not do it.
Right, I understand. The director shouldn't have that choice, is what I'm saying. That's why I say if those are the only circumstances, the irrevocable intention, then I would respectfully argue Mr. Justice Hart wasn't going far enough. If what you are doing, you are setting it, because it's so hard to work out when this irrevocable intention is formed. But if you are getting everything in position, all your ducks in a row, saying, just in case next week I form a settled intention, just in case I persuade my partner, my wife, my husband, that it's a right thing to do, and although it's risky, we're going to go on and do it. If I've got all those things ready to then go,
Well, one way of looking
you
at
should
it
tell
would
the
be
company.
if whilst directors, the defendants had heard that there was another company being formed and set up called Complex Claims, and that they had a website and they had and they were talking to Deminor to obtain substantial funding, would they have been under a duty to tell their fellow directors in the company about that?
I'd say they were. And
The answer plainly would be that they would.
yes.
Now, as soon as you reach that conclusion, they're in breach of fiduciary duty.
Or to take it further, if, for example, they became, and then somebody started to give them a tap on the shoulder and ask if they were interested in moving over, they ought to tell the company.
But you don't need to go that far.
No, I don't. No, I accept that.
Does that, but, so I think if you accept that, or that is the submission, you say that the factor that Mr. Justice Falconer found as a sort of constraint on that fiduciary obligation is actually not a constraint. In other words, I mean, he was saying that the rules of public policy as for restraint of trade have to sort of moderate the absoluteness or the strictness of the fiduciary duty, and I think you're saying no, the absoluteness of the fiduciary duty prevails.
And if one looks at Shepherd's Investments, it makes that exact point. It says these notions of restraint shouldn't trump the director's obligations in the circumstance of that case. And that, I don't know if my lord would wants to look at where this is dealt with. I'd have to just. It's addressed in Shepherd's Investments, and the reason it's actually expressly said in Shepherd's Investments that so far as it's necessary to choose between the two authorities.
Where do we find that? Is that
You'll
in
find it in tab
tab 1
1 of the first authorities bundle. And sorry, I'm just struggling to get the exact.
107, 108.
Exact appellant, thanks. Thank you, yeah. If you go please to page 25,
Yeah.
you can see that he starts to look at this. Paragraph 100 and, sorry, I should start at 104, forgive me.
104.
104, just because it introduces the Bolston case. So he says at 104, Mr. Quirk contended that Mr. Justice Hart's reasoning and conclusion are inconsistent with the Bolston line of cases, insofar as he held that a director is in breach of fiduciary duty if he fails to inform the company of any activity, actual or threatened, by another director or employee which damages the interests of the company, whether or not the activity would constitute by anyone of any relevant duty owed to the company, and there's a reference to that. And then at 105, as the most recent in the line of relevant authority, British Midland is binding on me unless I'm satisfied it's wrong. Far from considering it wrong, I respectfully consider both the decision and reasoning of Mr. Justice Hart were correct, and so far as there's any conflict between them and the decision and reasoning of Falconer and Bolston, the approach of Mr. Justice Hart is to be preferred. In my judgment, it's plain the necessary starting point of the analysis is that it's the fiduciary duty of a director to act in good faith in the best interest of the company, to do his best to promote its interest and to act with complete good faith, and not to place himself in a position in which his own interests conflict with those of the company. 107, it's difficult to see any legitimate basis for the trumping of those duties by rules of public policy as to restraint of trade as suggested in Bolston. There's no reference to any such principle in any of the relevant cases prior to Bolston, such as Robin Green and so forth. Mr. Justice Hart in Bridges Tool rejected any such principle and said at 89, it does not furthermore seem to me the public policy of favouring competitive business activity should lead to a different conclusion. The director is free to resign his directorship at any time, notwithstanding the damage that the resignation may cause the company. By resigning his directorship, he'll put an end to his fiduciary obligations as far as concerns any future activity, provided it doesn't involve the exploitation of confidential information. 108, what the cases show, and the parties before me agree, is that the precise point at which preparations, and then this is really these two bands. And then at so that referred to there at 108, perhaps I should take you to this because it's very important. What the cases show and the parties agree is that the precise point at which the preparations the establishment of a competing business by a director become unlawful will turn on the actual facts of any particular case. In each case, the touchstone for what on the one hand is permissible and what on the other is impermissible unless consent is obtained, is what in the case of a director will be in breach of fiduciary duties, in the case of an employee, breach of an obligation of fidelity. It's obvious that merely making a decision to set up a competing business at some point in the future and discussing it with friends and family would not be in conflict with the best interests of the employer. The consulting of a lawyer and other professionals may, depending on all circumstances, equally be consistent with fiduciary duties and obligation of loyalty. At the other end of the spectrum, it's plain soliciting customers of the company and the employer, the actual carrying on of a trade by a competing business, would be in breach of the duties and the obligations. It's the wide range of activity and decision between the two which will be fact sensitive. In this context, Mr. Justice Hart may have been too prescriptive in saying that the director must resign once he's irrevocably formed the intention to engage in the future in a competing business without disclosing intention to the company, takes any preparatory steps. On the facts in British Midland, plainly justified in concluding the preparatory steps had gone far beyond what was consistent with the duty in circumstances where the directors were aware a determined attempt was being made by a potential competitor to poach the workforce, and they did nothing to discourage and at worst promoted the success of that process, whereas their duty required them to take active steps to thwart the process. To taking my Lord's point, these two defendants knew Deminor wanted to get in the market, and that to that extent it inevitably would create competition, and they wanted to be the vehicle through which Deminor got into the market. And that inevitably would have an adverse, or risk of, adverse effect on CEL's business. So, in our respectful submission, the judge was just wrong to conclude that, first of all, this settled intention point was a key issue in the way in which he seems to have thought it was, which then influenced him. Because he then goes on at 324 onwards to deal with the question of when the settled intention was formed. I'm conscious that it's getting into findings of fact, which I submit are not relevant findings of fact, but even at first glance, to see the reasoning as to why he said he was comfortable in finding that it was late December or early January. The reasoning in our submission doesn't carry a great deal of, the greatest respect, logic to it. He says 327, well 326, I accept the defendant's evidence on this issue. I don't think there was any direct evidence as to when they say they formed a settled intention. 327, he thinks it's likely their decision was cemented when they received a strong indication on the 6th of January from the SRA. 328, the defendants resigned almost immediately after they received confirmation on the 6th of January. Well, that's not evidence that that's when they formed the settled intention. That's just evidence of them saying, we can go now, we've got everything in place.
Slightly naive view of intention as well, isn't it? I mean, you can have a settled intention which is conditional.
Yes.
You say, we will do it if we get SRA approval, or we will do it if we get funding. And at what point does
this is the difficulty?
What point does a conditional settled intention become an unconditional settled intention, and does it have to be an unconditional?
These are all the points I was trying to stress when saying this is such a difficult concept. The more important
question is, at what point does the intention of the directors and the intention of the directors and the actions and the taking of action to put it into effect become such as that consistently with their fiduciary obligations, they should either resign or seek consent from the...
If we're focusing on Deminor, it must be, if you're asking a question of fact, as it were, in this instance...
That's what the legal principle.
Well, yeah. Well, it goes back to those passages I was just quoting of the nascent commercial threat, when you know that there is a realistic threat to the company. You don't have to know it's definite, but if you know that there is an interest in the marketplace, which, if pursued and exploited,
it's quite useful always to look at it in terms of what would the defendant's position be if they heard about something that somebody else was doing.
Yeah.
And if they'd heard that somebody was thinking about it and had discussed down the pub that they might do it, you might think, well, that's nothing I need to report. But if you heard that somebody has actually set up a company, sought funding, applied for registration, opened bank accounts, you say that is something you'd have to report.
And if they were loyal directors and looking to the best interest, it wouldn't have occurred them not to make it. Would common sense says we need to talk about this, guys. We need to talk about this. We need to see what we can do. We need to go and talk to Deminor, or try and persuade them not to do this. All sorts of things. It's just obvious human nature, and self-preservation of your own business that you're doing. But well, my lord's made the point with respect.
But again, mustn't it depend on the business? I mean, here the judge finds there's a vast sea of potential people who want help in dealing with these claims. It's not as though you're in any sort of specialised business. There's a whole sea of people out there, and do you say, be obliged to report that somewhere at the other end of the country there's a firm setting itself up which is going to advertise on the internet and attract clients for this sort of one-off business? Really?
First of all, my lord, it isn't the other end of the country. It is. This is.
I'm testing your proposition.
No, well, it's hard to answer that in the abstract with respect, because this is a company. CL. The question for CL.
That's my point. It depends on the business.
Yes, I accept that, but I say that the facts of this business bring it full square within that obligation.
Well, I'm also struggling to see how Deminor is a nascent business threat when CEL has an agreement with Augusta. It's true, it's got this termination clause in it, but CEL have rejected Deminor in favour of Augusta.
Yeah.
What was the threat is what? The threat is, first of all, Augusta chooses to terminate the agreement. That's number one. Secondly, that CEL is looking for alternative finance.
Yeah.
And thirdly, that Deminor either can't or won't provide it. That's it. That's nascent, is it?
Well, yes, because it's about the opportunities for CEL, and it goes back to the basic obligations of the directors to protect CEL.
I think with respect to your mixing and matching there, I don't want to get into semantics, but there is one line of authority which talks about opportunities, maturing or otherwise. And there's a clear line of authority that suggests that where a company has rejected an opportunity, that after a period of time a director may take it up. I mentioned Piso Silver Mines as the case that I recall. And then there's a second question, which has got nothing to do with whether the company, whether it's a maturing business opportunity of the company which comes to the director in his capacity as the director of the company, which is the foundation for the doctrine. It's sort of property belonging to the company. Put that aside, there's a second line of fiduciary obligation, which I think is the one you're actually pushing, which is duty to act in the best interests, amplified where the interest may be damaged because you're involved in the potential damaging entity, which says that the company is entitled to have information from the director about something which may damage its interests.
That is the line.
So, and I think that there's a slight danger in the debate where we've been mashing together opportunity and interest. If you focus on the latter, so the one we're focusing on, there's some damage to this company I mean, my Lord's point to you, I think, was really that there are lots of people out there who are going to engage in this non-specialist field, and Deminor, we know, is interested in backing some of them to get into this business. So what's the damage if it isn't just facing a competitor?
Well, the question, first of all, Lloyd, is there a breach? The damage might be a different point, but I was just addressing the
Yes,
fact
what's
that
the damage that the company might suffer if it doesn't know about the fact that Deminor is about to get into bed with another company? What can it do about it?
Well, a loss of an opportunity to try to resolve itself, to maybe go back to Deminor, to maybe go back and try to
want to go back to Deminor. It's got its own.
It's already.
It's got its own Augusta.
Well, it has, but it might still want to keep its. The company might want to keep its options open for the future. The company might want to keep in the.
I thought what you were going to say is what it would do is it would try and go and prevent competition by trying to persuade Deminor not to engage with a competitor.
Well, that's what I was trying to make. It would have a conversation with Deminor to see how it might resolve to their mutual agreement.
Is that realistic? We've got Augusta. We just want to stop you, Deminor, from funding anybody else.
I don't know, but
Really?
I just don't know, my lord. But that's not my point. My point is it's not the job of Blanchfield and Montaldo to make that decision for me by denying me that information. That they should give me that information, then I'll use it and deal with it and work with it as best the opportunity might arise.
I mean, to some extent, the answer to some of these points, I think, is provided by Mr. Justice Hart's dictum, where he refers to the fact that it's a nascent commercial threat, maybe all the greater when the director was planning to be part of the threat. So it's not a third party at the other end of the country. It is somebody within your own company who is agreeing with Deminor to run a competing business, and that might particularly irritate Augusta when they see that the person they were negotiating with is now dealing with one of their competitors, and might make it all the more likely that they would trigger the default. That's your argument.
Yes, and just to put some extra on that, in circumstances where on the facts it was absolutely common ground that the two defendants were very heavily involved in all the negotiations, both with Augusta and Deminor. And indeed, in one place, Mr. Blanchfield, and I'd have to find a reference for you, Mr. Blanchfield sought to take responsibility, sought to take credit for having secured the funding from all the offers from all these people.
And did you? I mean, this line of argument about the potential umbrage that Augusta might take when it hears that key men have disappeared and are in league with Deminor. How is that put?
I didn't go to the extent of seeking to argue why Augusta might activate 1715 on the event default. I just said my argument was when they hear that people have gone, there's a risk that it might be activated. I didn't say they might do it out of umbrage.
Well, no, that was just my word.
So yeah.
But I just wanted to know the extent to which this.
I pressed this point. I pressed the point. I'll have to find the reference. But I went through in cross-examination in some detail clause 1715 with both Blanchfield and in particular Mr. Montaldo, as Mr. Montaldo being the lawyer.
I'm not suggesting you
No,
didn't.
no,
I just.
But I did.
It just hasn't come across my consciousness in all the paper we've got.
It was there. It was there in some detail in terms of this concern about what they were doing.
Because I don't think, unless I've spotted, I don't think the judge deals with this point specifically.
No, he doesn't deal with it at all adequately in our submission.
Yeah, but if you're going to make this submission and make it the focus of where we are, I for one would certainly want to see how it was. I'll just say that you don't need to deal with that now. But.
Right. I'll have to find those references, but I know.
Can I ask you this? The Deminor MOU
Yeah.
was sent on the 20th of January under cover of an email which referred to a meeting that day. And it's been sent in advance of the meeting. I'm presuming that meeting must have been set up sometime in advance.
Well, exactly. Again, this is the point that.
Can I just ask my question?
Forgive me.
Did you explore in cross-examination with the defendants what happened between in advance of the 20th of January, which led to that MOU being sent?
I believe I did, and I never got satisfactory answers. I think I got no more than we held regular 2 weekly meetings. 3 team meetings. So just for the reference, I'm told page 26. I think this is the area where I possibly dealt with this, my lord. It's in the 5th supplemental bundle, 2691. Where is it?
(2691).
That's what I'm told. I'm sorry, I'm just acting on the instructions of
number 4, I think. Called tonight.
Sorry, it's page 2690. It's internal page 208. And you can see I took just at the bottom of 207, went to the letter of the 16th of December. Then top of 208, on the 16th of December, they tell you they're not interested, yes. But then just over a month, on the 20th of January, they send a memo of understanding. So there must have been communication in some form or other between the 16th and the 20th. Yes, we had 2 or 3 team calls. And when did those take place? Generally fortnightly. So they said no on the 16th. Did you have another meeting with them before Christmas? I don't recall. It might have been before New Year. And that was a Zoom or Teams meeting. It was always Teams. And you and Blanchfield were together or separate. Weren't in the offices. They talk about where they had these meetings and chats and so forth. And then on page 209, line 30, if we look at 2411, that's just the internal. On the 20th of January, Tom and Mark, in advance of our call later, please see it.
Sorry, you've lost me now. Where's this?
Sorry, 209.
Yes.
Internal 209.
Yes.
At line 13, I'm taking him to an email, which might be the email that you had in mind, my lord.
Yes.
20th of January, and it's addressed Tom and Mark. In advance of our call later, please see attached a decision draft of the memo. So a gap of just over a month since they'd said no. You think you've had 3 meetings? Yes. And then what, the other 2 before you resigned and 1 after you resigned? I can't recall. And this memo comes and there's not a single piece of paper that's been sent. That's their proprietary work, not ours. But you've not sent them anything, no. And you've received an actual memorandum. Sorry, there was some cross talking. And then you can see 22, we had conversations over several weeks. Nobody's written any notes. So I was pressing about the lack of, and then the other oddity was this offer comes, but apparently there's no follow-up. They don't come back and say thank you yes or thank you no or anything.
And this is Mr. Montaldo's evidence,
This
is
is
that right?
Mr. Montaldo, yes. So this is what Mr. This is what the judge below described as surprising, the lack of documentation.
How does the, assume for the purpose of my next question that you're right and that this is a breach of fiduciary duty not to have informed CEL about the continued discussions with Deminor that you just showed us over this period. Brought it to the attention of CEO and didn't. How does it relate to the case you want us to send back to the judge?
Well, I can't point to a direct damages claim flowing from this breach. I'm in the context now of what the judge ought to have done and what he ought to have done in terms of giving me an injunction.
That's
No,
exactly why I'm trying to
No, I
understand.
understand. I don't think I can realistically say that I can show loss flowing directly from this breach in the context of Deminor.
Because it never went anywhere with Deminor. In terms of, there was never any funded trading by Deminor through.
No, I don't want to start. I don't want to start giving evidence beyond saying that I know on instructions that one of the other company funders, RPL, I think is it called PRL.
But that's why I asked you earlier. It would be one thing if one of the other funders was a company only controlled by the defendants. It's a different thing if the other company is an independent third party.
I don't think I gave you a full answer when I was dealing with that. I think we moved on to something else. I think I said there were over 20 companies themselves operating. We also know that these defendants have acquired their own law firm called Smith and Jones, and it trades as complex law. That's something that's happened since June last year.
Complex law, not complex claims.
Complex law.
Funded by?
Funded, we believe, by one of those four called RPL.
But we're getting into some. But what I think you've given the answer. I was trying to just connect this debate with what you say you actually are in a position or might be in a position to.
I can't immediately say that I have a direct financial claim arising from these discussions and negotiations with Deminor. But clearly, they point to, we say, why there ought to have been a springboard injunction at the time, we say.
Ought to have been, not ought to be now.
No, ought to have been.
You're not claiming a springboard injunction anymore.
No. I'm not asking you to impose a springboard injunction. When we claimed the relief that we did in our appellant's notice, of course, at that time, if the appeal had come on earlier, there may have been a period of time when we were still in the time frame, in the time periods. Just going back to the judgment, if I may.
And the springboard injunction that would have, just trying to think, you say that you're not asking us to do it, but you say the judge should have done it, I think.
Yeah.
How would that have related to Deminor?
Well, it would have just been a blanket springboard. It would just been an injunction to restrain them from conducting any business in competition with us. That's the form of the springboard that we're asking for. It was a broad prohibition on.
So you wouldn't have tied it to
Specifically
the breach of fiduciary duty. You would have just said you've breached your fiduciary duty in one respect, but therefore we want an injunction preventing you from competing. Full stop.
Well, of course, I was arguing in front of the judge that there were a whole host of preparatory steps.
I'm sorry, forgive me. I'm just trying to connect the points you've been making about Deminor and have been putting forward to us, and we've been exploring for the last hour, I think, with what you say either should happen now, which we've been through, or what the judge should have done.
Yes.
And your answer, I think, is that once you get a breach of fiduciary duty, you get a blanket springboard injunction, or does the springboard injunction have to?
The
connect in some way.
Yes,
with breach.
the springboard has to be crafted and designed to prevent them taking advantage of the fruits of their wrongdoing.
Of the springboard. I mean,
Yes.
if the springboard is the breach of not telling you we were talking to Deminor, what my question, I suppose, is should the springboard injunction be limited to not trading with Deminor through financing? Sorry, not trading in a way that's financed by
Yeah.
Deminor, because that's the springboard
Yeah.
that they've given themselves illegitimately, or is it a more general? You know, because I'm struggling with the concept.
The reason I've got a difficult, of course, we didn't break our application down in that way. We didn't say we've got 10 allegations of breach. If you find number 1 broken but not 2 to 9, then this is the
But
relief.
if you're criticising the judge for, you know, as well, what not doing something which he ought to have done, I'm trying just to be clear about what it is you say he should have done, and I think your submission is. You, by injunction, deprive the defendants of the springboard that they have illegitimately given
Yes.
themselves. In
So my starting point was, and my starting point would be, the judge was wrong entirely to reject all of our allegations of improper preparatory work. And those preparatory steps started in mid-August. And we know, for example, during the middle of garden leave, they were still going on the 20th of January. Now, they related to different things, but that's a 6-month period of activity, which we say was improper. And they were springing themselves forward in order to get all of that work done and get it out of the way while they were directors. And they shouldn't have been doing that. So the springboard should have taken that benefit away from them. And so it would have been a 6-month, as a minimum, period of restraint, generally, on that analysis. But if my lord said, well, he was right, the judge below was right to reject everything else, but he was wrong on Deminor, and we didn't argue it this way, the question wasn't posed in this way, then I can see that there might be a need to be a bit more precise in terms of what the relief is. Part of the difficulty with respect is that we dealt with closing submissions in writing. There was no exchange of this kind at any stage at all. During every judge with respect is different. Some are more interventionist than others. But during the course of the whole trial, that wasn't.
No, don't worry.
During the course of the whole trial, I think the judge said 3 sentences, and there was no detailed analysis at all of the openings, which were very short, and there was no analysis at all of the closings. And that's why I suggested that it might have been beneficial for there to have been.
The judge found that any advantage which the defendants got out of Deminor would have been 2 to 3 months.
It's hard to see how we drew that conclusion, bearing in mind the length of times that the negotiations were being conducted over. The meetings alone, 5th of October and then one on the 5th of December, there were preliminaries before the meetings were set up. The discussions were taking place every 2 weeks.
But I thought that Deminor's position was no until,
I can only go on the emails we've got. The position was no on the 16th of December, but they still were in contact with each other. We know that. They had possibly 3 further meetings between then and the 20th of January, which doesn't suggest it might be thought that it was all over. But I can't go any further. I can't go any further than that. But the notion of 2 or 3 months, but even if it was 3 months, a springboard, that's not so de minimis in the context of saying to somebody, you've jumped the gun, you've got to wait a bit longer. The judge seemed to think that 3 months wasn't worth anything. So, I think, Lords, I probably said about as much as I can in terms of the allegations of breach. Everything else, in a sense, is pretty secondary. I hope I'm pretty realistic that if I'm not going to get very far with my main points about breaches and so forth, the others are additional points. But there is one perhaps to stress, And that, if I just introduce and I can deal with it quite briefly after we
Yeah.
come back. But in terms of his rejection of a very significant piece of evidence, that's in relation to the OneDrive. We do say that his approach was far too restrictive in his rejection of very compelling evidence in respect of that. What we had, I'll just set the context and the scene before I get into any of the detail, if I may, is we had evidence from both Paul Hampson and his sister Laura Hampson, which we say was not expert evidence. It was quite simple evidence in terms of they were reporting what they had observed when certain matters were drawn to their attention by an IT expert who was cleaning, as I understand the phrase is, cleaning the laptop of Mr. Blanchfield. And they explained, and I'll go into the detail when we come back, they explained in their witness statements that what they had discovered was on an industrial scale, the movement from the CEL N drive, as it's called, of CEL's files, which contained contact names, client names, addresses, telephone numbers, policies, NDAs, all sorts of templates, marketing material, a vast amount of documentation. They'd found that their N drive on those files had effectively just been transported over to Mr. Blanchfield's OneDrive. And a simple comparison of
So
screenshots.
I understand it. When you say OneDrive, you're talking about a virtual drive, or are you talking about a drive on the laptop?
It's a drive on the laptop. My Lord may have heard that. If you're going to ask me too many detailed questions on this, my Lord, I'm going to struggle. But it's a OneDrive which is his own personal storage facility.
The reason I ask is before we go any further, because certainly because my OneDrive is not on the laptop, or it's not on a laptop, for example.
I'll have to get the
Yeah,
details.
it's cloud-based.
But they were able to discover that he had access, whether it be on his laptop or whether it be via cloud-based. They were able to discover that on his own personal storage facility, wherever that was kept, called a OneDrive, all of their files had been transported. And there were screenshots that were made available to the judge. Simple screenshots to show there's CEL's OneDrive, N drive, there's the defendant, Mr. Blanchfield's OneDrive.
So what I'm in, an N drive, as I understand it, is a cloud-based drive. No, doing lots of shakes of heads behind.
I'll need to take
Okay,
instructions.
well perhaps we can do it, but I certainly.
Whether with respect, I'm not sure that it makes any difference to my point, which is that my point is that in terms of the rejection of the simple rejection of evidence.
The reason I asked is because you're starting to get into sort of, you say, look, this is very just simply factual witnesses saying what they saw.
Yes.
But the point is they saw it as a consequence of an IT expert doing something.
I see.
And conventionally, my understanding would be that you would have the IT expert explain what he was doing, because he's the one who knows what he's doing. You wouldn't normally just have some inexpert observer give evidence. That's the issue that I wanted just to tee up.
Okay.
But none of that would have stopped you putting the documents to the defendant in cross-examination.
Which is what we tried to. Well, I didn't do. The reason I didn't go into it in any detail with the defendants in cross-examination is because my clients, in their witness statements, had dealt with this at great length to set out what was there, what had happened, and they were not challenged on any of it in cross-examination. And so and there'd been no answer when we pleaded points to this
So
particular.
what was it that was not admitted then?
The defendants didn't address this question in their defence at all. We didn't really have any explanation from Mr. Blanchfield beyond, as I understand it, conceding that these things were on his storage facility. We had no explanation.
But forgive me then, what is your complaint about what the judge did?
But the judge just chose to say this, I'm uncomfortable with this evidence, I'm going to have no regard to it whatsoever.
Well, he did said that about Mr. Muldoon.
There was a Mr. Yes, he was
He was apparently an expert.
yes, he was. And we tried. Sorry, my lord.
And that's what the judge deals with at paras 189 to 197.
Yeah.
He has a bit about the OneDrive between 145 and 152. Well, are you saying the judge was wrong not to admit the evidence of Mr. Muldoon, the expert?
No, I can't. No, I can't deal with the evidence. I can't deal with it on that basis.
So
what I say is he was wrong.
What is he not accepting in 147 to 152?
It's not there. It's where he at paragraph 273, I think, says at 273.
Oh, I see. Yeah.
He says he's uncomfortable.
274. He goes on,
Yeah.
and then he says at 276 it's not pleaded.
Well, in terms of that's a different point, of course. He didn't. I don't think he rejected it. I think he accepted, given the way in which the case had been put together, that information was coming out and we were finding information.
Yeah.
I mean, you have to attack 275, don't you?
Yeah.
And,
That is what we're
and
attacking.
274 when he says that Miss Hampson was not aware of what OneDrive was.
Right.
Until it was
But
explained.
in re-examination, I asked her if she knew what a OneDrive was by the time she came to prepare a witness statement, and she said she was. She said she regarded it as a storage facility.
All right. Well, shall we break there, Mr. Chasty? How are we doing for time?
I think I'm doing pretty well. I think I'm no more than half an hour at home.
From the end of your submissions.
Well, I'm not going. I think I've gone through a lot of the points without having to. I've got.
No, fine. I'm
probably
just
isn't.
asking.
Could I ask you?
I'm not. I probably no more than an hour, but
Okay,
half an hour to an hour.
fine.
Could I ask you, over lunch, I haven't been able to find, in the chronology it refers to Mr. Montaldo's resignation letter of the 10th of January, and although it's got the trial bundle reference, I haven't been able to find it in the agreed bundle, unagreed bundles.
I'm not sure if it's in the bundle, my lord. We can. I suspect it's a pretty short piece of work. We'll have a look.
All right.
My lord, sorry, before you rise,
Yes.
quite a lot this morning was given effectively by way of evidence by my learned friend. I don't have my clients in court. We shall endeavour to do what we can to try and find out answers to the extent that they are relevant to the issues on appeal.
Yeah. Thank you very much. 2:05.
All rise in April.
Let's just go and have a talk back to the end.
Nothing.
Would you like coffee?
What I'll do is just have